Mulaz, the last date is tomorrow, Mulaz. This has been heard twice. I'm requesting if your lordship can grant me upgradation if it is not called out in the first.
It is that lift matter of
matter.
Otis.
Please, please.
They were supposed to.
They have not filed.
They are supposed to file an affidavit wherein they have to disclose.
But
After the
it has been-
committee had found 3, how could the other 2 be? That's the.
that's
They were
Very-
supposed to file, but
Don't worry, we'll reach there.
Please,
We'll be
please.
there.
I'm grateful.
We'll be there. 20. So don't number file to motor is table order, sir. 20 years. Huh? Your case is that matter is settled by division bench, single bench, and the Assam Board of Revenue. Assam religious institution that. Okay. Okay. Have you given a copy to the petition? Disposed of. Disposed of, we'll get the order on Monday. We are remanding back the matter. Biswajit Day will take some time, not possible today. They are already very tied up. We'll give a date. On that day, we'll do it. Item number 4, disposed of. Date date 4 disposed of. Yeah, matter. Yes, Ms. Devi. Where is the survey report? Oh, why? You written but this was directed on 16/6. You have done nothing. Why? Why this order of the court was not complied with? 16/6. There is directed that no further adjournment would be granted to the respondents for the purpose of bringing the survey report on record. Who has written to the DMR? Why? Why the delay? Because this undertaking was given on 16/6. Show me the communication. Why the delay in the part of the circle officer in taking action in pursuance to your letter? Huh? Full stop. Mr. N. Goswami. Mr. Devi will give them one more chance. Mr.
Can one mail?
Huh? How many? Heard Ms. L. Devi, learned counsel for the petitioner, and Mr. N. Goswami, learned government advocate appearing for the state respondents. This court had wide order dated 16/6/2025. granted liberty to the Deputy Commissioner to carry out a verification of the survey through the concerned revenue staff so as to ascertain, whether the drain in question has been constructed over 9 lessa of land of the petitioner as alleged by him in the writ petition. Full stop. It is seen that the said matter, the contents of the order was communicated to the District Commissioner Kamrup Metro, Guwahati, by the learned government advocate on 19/6/2025. However, there has been a delay in carrying out the said survey, and the circle officer and the jurisdictional circle officer had written only on 28/2025 to the Director of Land Records, Assam, for carrying out the said survey. Also, Mr. Goswami submits that the delay was on account of a miscommunication occasioning in the matter, and the respondents be condoned for the same. Also, in view of the fact that the said survey report is also mandated for a due and proper adjudication of this case, this court reluctantly grants further 4 weeks' time to the petitioners herein to complete the said survey and place before this court the report and along with an affidavit from the competent authority. Full stop. Registry to list this matter again after 4 weeks on a date after 4 weeks after the ensuing vacations on a date to be fixed by it, or after the ensuing vacations on 17/10/2025. यही खुराई दी बात है। Yes, Mr. Goswami, you will be arguing the matter. He is on legs. Mr. Saraf, can this matter wait for some time? Because any urgency here, or can it be have it after the vacations?
Urgency that I'm not getting.
So, yes. Okay,
Yes, come, Milord. Yes.
ready. But the only problem is they are too tied up. My hands. Can we have it next week, Wednesday or
Let
Thursday?
me hear it and Milord, it may come later.
No. I have heard enough. I have enough with me. Enough food for me. Vacations is also taken care of. Okay. But the only problem is I may not be able to complete it. That's the only fear. It is with regard to that implementation of the industrial policy. No, I'm free. There is no problem because it's a motion day. I'm not taking up any other benches till now. 23rd, Mr. Saraf. We'll have, or we can have it on 18th also. Huh?
Just near vacation.
Then let us have it on 16th. 16th. As agreed to by the Learned Council for the parties, registered to list this matter again on 16/9/2025. It's always a pleasure because I get to learn much more things when I take up these matters.
Next matter.
Yes, Mr. Gogoi. What is the instruction? Hmm. 18 of the writ petition.
731.
731.
Hmm. That is that cost of DG. Huh. Hmm. 0. Revised so and so 7,61,000. Hmm. So you agree that he is entitled? Okay. So in all the cases, writ petitions, the
Milord,
DG set was
chart
brought
has-
on record.
Chart, I have made a chart. Milord.
No, fine. The DG set was brought on record, right? And in all these cases, the installation is done and it is running. Hmm. Mr. Chaudhary, I get one like this daily when the matter is, I think 1 or 2 is already available. Okay, anything left? We'll allow the writ petition, you take into consideration, verify, and then make the payments. Dispose of. 6, 7, 8, 9, 10, 11, 12. We'll pass one order because there is no dispute. Dispute will pass one order. Yes. Okay, okay, okay.
Amount is it?
Amount defined, madam.
Okay, fine. We are only concerned with the principle. Yes, Mr. Mandal.
My lord, this is getting cell permission.
Similar order.
Yes. My lord, we have,
You go back, give the documents. Hear it.
we have
this
already
was-
furnished the, my lord, similar order in the earlier. order.
I passed some orders. We'll pass.
Obligation.
Anything?
We have a big family.
Hey, don't Namgita likilo. Any objection in remanding back the matter? Okay, thank you, Vadio. Senior, let the senior come. He may have something to throw light, maybe. Yes. Where is your IIT? Mr. Das, get hold of IIT. I told you there is no need to upgrade, but now it's gone. Get the counsel.
Legal.
16th, 21. Mr. Saraf, you are here in this series. What is to be done today? The PML.
For final disposal.
We'll have it after vacations.
As you know,
I think this can wait before vacation. Also, as about as agreed to by the Learned Council for the parties. Also, as stated in the pleadings in the matter is complete, and the parties have prayed that they have submitted that the matters be taken up for final disposal. Also, give me a date, Mr. Any date. No, any date convenient to you.
policy measures to be taken. After, the order was passed by the judiciary authority. In spite of the order passed by this.
That has also been taken care of. That was brought to the notice of this court.
But no order has been passed. So, the only thing that, the policy measures, whatever measures are there, no further effect should be given to this order also, I filed the interlocutory application.
Give me a date.
Thursday. 9-10, Secondly,
Subsequently. Oh, okay, 9-10, no problem. Or 11-11, that will be better. 11-9, 2025. We'll pass the orders.
11-11.
11-11.
9 is only going on now.
Okay.
Somebody is going on,
Or can we have it sometime in October? On 14-10-2025. Mr. Dr. A.K. Saraf, Learned Council for the petitioner, submits that this court had had wide order date, had passed directions in the above noted writ petitions. Directing the respondent authorities not to take any coercive action against the petitioner. Full stop. It is submitted that although the said order is currently in operation, the respondent authorities have passed orders. What is the nature of the orders?
That is allowing the retention of the movable property documents and all those things.
have passed orders which would be in violation of the directions passed by this court. Full stop. The respondent authorities are required to act in accordance with the directions, interim directions passed by this court, and any grievance existing in the matter of the petitioner shall be considered. Yes, Mr. Chaudhary. No, it's okay. We are not taking it up. We are, after the vacations, we'll have it. You take your breath, take your breath. It's age catching him.
That I pointed out.
Itu Katidiasan, Had Dr. A.K. Saraf, Lanak Counsel, Senior Counsel, appearing for the petitioner in WPC number 2808-2025. And other, and you are in 23, 24, and 25.
All cases, my lord.
All cases. So, learned senior counsel appearing for the petitioners in the above noted writ petition above order Mariva, assisted by Mr. P.K. Bora, learned counsel for the petitioners. Full stop. Also heard Mr. R.K.D. Dev Chaudhary, Deputy SGI, along with Mr. R. Dhar, appearing, learned counsels appearing for the respondents. Mr. R.K.D. Chaudhary, learned counsel for the learned DYSGI, submits that an affidavit would be filed on behalf of the respondents to bring on record the subsequent developments taking in the place in the matter after filing of the writ petition. The said affidavit would be filed on or before. When are you? Give me a date. 27, then we'll have to give him some time to respond. You file it a little ahead. You have everything with you.
Your vacation is there, my lord, everything is.
Okay, 27. 27/10/2025. Petitioner shall thereafter, within a period of 2 weeks, bring on record his rejoinder. Its rejoinder thereto. Full stop. Register to list this matter again on 11/11. Done. Your date. What do you wanted?
You know, the only thing that I made some.
I'm coming to that. 11/11/2025. Full stop. But you are taking coercive action. There is a bar here. You said that they have issued some notices, orders.
Order.
It is submitted that although Mr. R.K.D. Chaudhary, learned counsel for the respondents, submit that the respondents have not taken any coercive action against the petitioner in terms of the interim directions passed by this court in the above noted writ petitions, and the said position would be maintained till the next returnable date. Fine. Don't take any. I have only said with regard to coercive action. Don't take anything. We have just, Mr. Saraf, that will suffice.
That will need this. Must be this order also.
No. I have said that he has said that they are not taking any coercive measure and they'll continue with that position till the next date of listing.
I'm cooperating. How much I should cooperate?
That is a very
Going to the
vague
city-
term, Mr.
I'm asked to sit from morning 9 to 8 o'clock. It is cooperating, my lord.
They are also very busy.
They are not busy. They are harassing.
No. We'll come to that. I've said that they are, he has undertaken that no coercive action has been taken and they will not take any coercive action till the next day. I think that will be,
Against this order, my lord, with the past. Appeal lies.
we will not appeal.
Appeal lies, my lord.
Huh.
Against this order. The adjudicating authority, whatever the order passed.
22/7.
If they-
But that period will go off if the writ petition is pending.
How they can take care, my lord?
It is further provided that in the orders passed by the adjudicating authority in the meanwhile during the pendency of the present case would be considered at the time of final disposal of the present writ petition.
I'm obliged, my lord.
So bring it on record also.
Oh, my lord, I brought in the.
Oh, God.
Item 15 was my end is.
I'm sorry.
Just give me 2 minutes.
My lord, my name will be recorded, my lord, in this.
Mr. Also heard A.S. or A.K. Saraf Buliasana, along with so and so. Also heard Mr. S.P. Sharma, learned counsel for the petitioner in
My lord, in the supplementary list.
AK Saraf, so and so assisted by so and so, along with Mr. SP Sharma, learned counsel for the petitioner. Hmm.
16.
Yes. Written argument?
Yes, my lord. Ready, my lord.
Give me.
My lord, so that, my lord, I want to place one document, my lord.
You want to argue the matter again? What?
No.
Then-
One document, my lord, I will want to.
Why? How can you give it by hand?
My lord, it
Where is your written argument?
yes, my lord, it's
Hmm.
ready, my lord.
What? You have brought that on record. Okay. That chart which you gave me, how the posts are moved, that will also be now have to be taken into consideration by this court.
Okay, my lord, if you will also.
Please.
Regarding, my lord, the SM Das, my lord, who was appointed, my lord.
He was also of the same trade.
Yeah, my lord, but, my lord, I got his, my lord, appointment letter. My lord.
Give me.
That letter, my lord, only.
Why are you hesitating? Give it to me.
My lord, lordship says, my lord, it-
No.
Cannot
Give
be
it to me. Any material which will have a bearing, we will consider.
Well, this is the appointment letter of my lord. You see, one, my lord, what I'm so.
Mr. Hussain will have no problem.
My lord, the, my lord, this is-
Consequent upon so and so, ascend as Turner grade 1.
my lord, kindly see, my lord, thereafter, my lord. Second paragraph, the basic function and responsibilities attached to the post of skill grade 1. My lord, skill grade 1 promoted as master craftsman. My lord, it is not mentioned, my lord, from my lord Turner.
No. That will be Turner only. He is grade 1 Turner. I thought it's something else. He is Turner grade 1. So when he becomes any grade 1 becomes machinist.
Hello.
Master craftsman. Master craftsman is from Turner, fitter, and all those cadres. So they will be continued to which may be added such other duties and responsibilities as this is just indication.
The honorably learned tribunal, my lord. That, my lord, learned tribunal never held that, my lord, the my lord, promotion of my lord H.C. Rabha, my lord, as bad, my lord. Only says that, my lord, they are not given, my lord, the benefit of, my lord,
That is something else. We'll take care of that. Let us come to
my humble submission is that, my lord, that my lord, from all grades, my lord, there is only one post at that point of time, my lord, and from all posts, my lord.
that this was considered.
My lord.
Whereas he said that this is going from Turner, so I should get it. You say no, this is open to all.
All.
Whoever was the senior most, we have given to it. In spite of the fact that they were declared surplus and brought here,
My lord.
but for that thing they were considered there.
My
And
lord.
the promotion was. That's the case. Done. Heard Mr. G. Goswami, learned counsel for the petitioner. Also heard Mr. A.K. Hussain, learned counsel appearing for the respondents. Also, hearing completed. Petitioners have appeared. The learned counsel for the parties have placed on record their respective written arguments. Also, registry to list this matter again on 16/10/2025 for delivery of orders. File move declare one. Eto mati dia 15.
15.
Yes, they seem to have not cancelled the tender, my lords.
Tender has been cancelled, and rightly so. You have saved us from passing a detailed order.
May I just,
Mr. Counsel, we are coming back to you. Don't worry. Okay. Yes, Counsel. May I have your name?
Bhargav Vasurkar.
Hmm.
The last time when the matter was argued, it was they were citing urgency on the ground that the tender is for taking out the old lifts and installing new lifts. They were citing urgency that handicapped people have not been able to use this, and therefore this extension should not be granted. They've cancelled it. It's going to take 4 more months for them to. I understand their discretion to cancel it, because I am at a place where again the same lifts, same brands. I am only against insertion of brands. The Lordship may at least grant me liberty that in an event that similar condition is inserted again, I have the liberty to merge.
Mr. Counsel, this closure of the writ petition is not for a default on your part. This is for taking away the cause of action. Any pleadings that you have brought, any points you have raised will always remain open to you in future. And say, this may be because of a fact that they also may have lost sight of the fact that the technical committee had only recommended 3. They had brought in the NIT the other brands also, which is a fault which goes to the root of the matter, and it could not have sustained judicial scrutiny to that extent. The 3 would have, if it was only 3, we would not have been with you. That is their discretion.
Because even in three brands, even if it was 3 brands, Mulods, the circular issued by the Prime Minister's office, including other 15, 16 high courts and the Supreme Court, say that you cannot insert brands. You specify technical specifications. Yeah, I qualify or I don't qualify. I have
No.
not shied away from the fact that I cannot
We'll examine it in a given case. But here I've gone through the reasons assigned, and they have given certain reasons, and which I feel in the northeastern region would be germane to the issue. Because you have a lift installed or anything installed, and you don't have a service personnel posted here. So the earliest they have to come from Calcutta. That I'm not just what I found, I'm saying it's not a conclusion. So it may take 2-3 days time. It has happened. So whether the employer will not have that discretion to take that factor also into consideration.
Correct, Manoj. Your lordships are absolutely right. That is a technical parameter wherein they may specify that if you do not have an established service
I got
center,
I got it.
that is a different thing. But
I
you
got
say that such and such brand only.
That
Therefore,
may be.
this writ petition is over. I am inspired. Apart from specifying brands, there are technical parameters.
Yeah,
which
they
been
could have done
specified.
it. They could have done it.
So it's over refinement, which is impermissible in my respectful submission.
We'll test that in a given situation.
Only if your lordship may consider my submission that I am praying for liberty. Your lordship may consider it.
I'll give you liberty. Don't worry.
Please, your lordship.
But Mr. B. Hasrukar, am I got it right? Learned counsel for the Hasrukar and Mr. Adas, learned counsels appearing for the petitioner. Also heard Mr. A.B. Day, learned counsel representing the Indian Institute of Technology, Guwahati. Also, the matter, the present writ petition was instituted by the petitioner presenting a challenge to a tender notice dated 24/6/2025, inviting bids for installation of 4 numbers of 8 passenger, 4 numbers of lifts with capacity of 8 passengers at one time at various sites of the IIT Guwahati campus. The grievance of the petitioner was that the said tender was so issued by limiting the invitation of bids to certain brands selected for the purpose. The petitioner contended that the said selection of brands would not be permissible to be made, and the bid ought to have been so, and the NIT and the tender notice ought to have been so issued by only specifying the technical specifications mandated for the purpose. Also, this court, while order dated 22/8/2025, while issuing notice in the matter, had directed the IIT authorities to extend the date of submission of the bid. Also, the said order continued to hold the field. Also, on the last date of listing, that is on 26/8/2025, the IIT authorities had placed before this court the report of the technical committee constituted in the matter. Also, this court had, on perusal of the same, found certain inconsistencies, and the same was required to be clarified by the IIT authorities, and the matter was listed today. Also, subpara. Today, when the matter is listed, Mr. A.B. Day, learned counsel appearing for the IIT authorities, has placed on record a communication dated 3/9/2025 received by him, wherein the IIT authorities have intimated him that the NIT dated, that the tender notice dated 24/6/2025 has been cancelled by the institute on account of certain technical reasons. Full stop. The NIT dated 24/6/2025 subpara having been cancelled, this court is of the considered view that no further live issue arises for consideration in the present writ petition. Also, as the matter, accordingly, the writ petition would be mandated to be closed. Full stop. As the writ petition has been closed on account of the fact that the tender notice dated 24/6/2025 impugned in the present proceedings has been cancelled, the contentions raised by the petitioner in the present writ petition shall remain open to be so contended in the event any further cause of action arises in the matter in future.
Please.
A copy of the communication dated 3/9/2025 furnished by Mr. A.B. Day is kept on record and marked as X for the purpose of identification. With the above observations, the present writ petition stands closed.
I'm grateful, Braj.
Hope that takes care of your apprehension.
Please, yeah.
Yes, Mr. Gus. What?
My lord,
NH Act. So compute the matter under the Act. Done.
will be started.
This whole writ petitions are with Dolakhal Kolitakusi Road. Mr. Islam, the writ petitions are with the Dolakhal Kolitakusi Road. All the writ petitions.
Yes, 3 writ petitions. This pertaining to Mukalma area, that Borkhetri Revenue Service, Dolasal Kolita Gusta.
That only, Mukalma will fall within that only.
Lordship, may kindly have a look, the order dated 24/7/2025. As by this court.
Therein this court has recorded that the matter would now be, the issue would now be, the land would be acquired under the National Highways Act, 1956. Right? Right?
Lordship.
What is that?
So we challenged the proceedings earlier under 1894 Act.
So that is gone now.
That is gone, so. new
This
act
will be
come
done.
and
If it is done, your
the
liberty
notice
is
has
open.
been done, the interim order was operating.
Now we are vacating it. Now they say that the earlier proceedings we have given up.
So.
Now we will initiate fresh proceedings under the National Highways Act.
Act 1956. Accordingly, fresh acquisition proceeding will be there and will be a new compensation.
That now you will get the better compensation.
They will issue notice afresh. Everything will be new. My lord,
Afresh, my lord.
Yes, yes, yes. That will give us adequate relief. My lord, one substitution petition was there.
No, substitution petition we are not going into because now okay,
Person died. That's right.
Entire process will be.
Yes. Ultimately, what relief we have sought in our writ petition?
that you have been granted. Now, today they
No.
have been granted that.
So earlier proceeding has been quashed. Whatever it be. সেইটো নহয় নহয় মানে instruction সেইটো আমি দিছো Oh, this much of preparation I have done now, no need. Yes, they'll say.
Had Mr. S. Islam, Learned Counsel, तीन tackle
Islam.
R. Islam, Learned Counsel for the petitioner. Also heard in all the writ petitions.
Or in all the petition.
Also heard Mr. B. Goswami, Additional Advocate General, appearing for the respondents, state respondents, in all the above noted writ petitions. Also, in the present batch of writ petition, the challenge is to a process of acquisition of land initiated
1894.
under the provisions of the Land Acquisition Act 1894 for construction of Dolahal, DOULAL, Dolahal dash Kolitakusi, apostrophe bitorde, road under the Northeastern State Road Project, bracket NESRIP. Also, the proposed road would pass through locations of Dodora, Singimari, Hazu, Mukalmua, Rampur, Dolahal, Borpeta, Hauli, etc. And the petitioners who are residents of the area wherein through which the road would now pass had instituted the present proceedings apprehending the
Taking it to be an illegal proceeding where notice was not properly.
apprehending that the provisions of the Assam Nutun Asil na Fair Act
1894.
2000 under the apprehending that the provisions of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013 would not be applied in their cases, and the compensation would be determined under the provisions of the Land Acquisition Act 1894. That's
No,
your
no,
grievance?
no. That has it is opposite.
Arey, that
1894 we challenged. And we wanted that 1894 that proceeding in which we did not get notice and we could not file objection.
When did you file your writ petition? 15th.
15. So we wanted to, we were quashing and fresh acquisition.
Second place, my lord.
No, Lordship, let us clarify. We
Okay.
wanted.
No,
that-
লেখা, লেখা, কাটি দিয়াচোন।
We
the
wanted
peti-
that
okay,
that
okay, okay.
proceedings
A
to
roads
go
will pass
to
through
third
this place,
tribunal.
no? The petitioners had instituted the present proceeding, assailing the land acquisition cases initiated under the provisions of the Land Acquisition Act 1894. And had prayed for a direction upon the respondent authorities to initiate such accusation afresh under the provisions of the right to fair compensation, right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, Act 2013.
Correct.
So, the matter, this court okay, fine.
That-
We'll not go into that. That is gone now. That is gone.
That is
That's
gone. That is gone.
I just recorded. So,
We have filed.
on 24/7/2025, when the matter was taken up for consideration, the learned counsel appearing for the respondents had informed this court that had apprised this court that the learned counsel for the petitioner, respondent, petitioner had apprised this court that their lands would now be acquired under the provisions of the National Highways Act, 1956, and a process in this connection was already initiated. The learned counsel for the respondents appearing in the matter had sought for an adjournment to complete his instructions. Accordingly, the matter has been listed today. Today, when the matter was listed, Mr. P. Goswami, additional advocate general appearing for the state respondents, has placed on record a communication dated 4/8/2025 received by him from the District Commissioner Nalbari. Also, a perusal of the said communication would go to reveal that already a process has been initiated, has submitted that the Ministry of Road Transport and Highway on 22/1/2025 issued a notice along with copy of minutes dated 7/1/2025 regarding project management consultancy services for geometric improvement and widening Horu T2 normal 2 lanes with paved shoulder from end of proposed by Borpeta bypass to Amingaon, which was forwarded by the executive engineer PWD Guwahati NH division on 4/2/2025 with a request to initiate the process of land acquisition by appointing CALA as per National Highways Act. It is further seen that on receipt of the said communications, a meeting was held in the office of the District Commissioner Nalbari of all the stakeholders involved in the project. Accordingly, it is seen that the additional District Commissioner bracketed LA bracket over, Nalbari was appointed as the competent authority of land acquisition bracketed CALA on 23/5/2025. Also, in view of the said developments and the matter now being undertaken to be, and the matter of land acquisition of land of the petitioners now being undertaken to be so done under the provisions of the National Highways Act 1956, The grievance raised by the petitioners in the present writ petition stands redressed.
Earlier impugn proceeding.
No, that is gone.
Gone.
That is already gone. For some,
Maybe-
in view of the above discussion, this court is of the considered view that the present writ petition, that the respondents are, in view of the above discussion, the present writ petition stands disposed of, requiring the respondents to take the process initiative for acquisition of lands for the construction of the Dolasal-Kolitakusi road in the manner indicated in the communication dated 4/8/2025
Particularly. land
to
sale
its
for-
logical conclusion by strictly following the provisions of the National Highways Act 1956. In the event the petitioners have any further grievance in the matter with regard to the acquisition of their lands under the provisions of the National Highway Act 1956, they are at liberty to take appropriate steps in accordance with law for redressal of their such grievances. With the above observations and directions, the above noted writ petition number kita diriba. With the above observation and direction, the writ petitions being WPC number so and so stand disposed of. Interim order passed earlier stands vacated.
My lord, to become more clear, that impugn proceedings are.
That is already undertaken. Why should we? They have given up. Why a given up proceeding we should go and quash? Why should we quash it? Mr. What is your IA for substitution?
That in one, that is, father died, who was a writ petitioner.
Where IAC, which one?
In WBC 1128.
616.
1128, IS civil number 1377.
1377. 1377 Mariba. No, order to Mariba. Order to Mariba. Uporot. At the outset, Mr. R. Islam, Learned Counsel, has submitted that the name of the petitioner number 10 in WPC number 1128/2025. Another submitted that the name of the petitioner number 10 in WPC number 1128/2025 had, during the pendency of the present proceedings, passed on PASSEDON, on 6/5/2019, and an interlocutory application being I bracketed civil number 1377/2025 has been instituted by the present has been instituted for substituting the name of the petitioner number 10 with his legal heirs. Also, on perusal of the said interlocutory application number 1377/2025, this court allows the same and permits the substitution and permits the petitioners to substitute the name of the petitioner number 10 with the names of his legal heirs, that is
Dilruba Yasmin, Mirajul Habib.
page 15
Page 15.
A. Well, I. So the present order is being passed by considering the substitution of the name of the petitioner number 10 with his legal heirs in the manner noted above. Done? Tar bisot tumi order to my riba. Tar bisot tumi order lihiba jikini IAS in view of the directions order passed today in WPC number so and so. No further order is required to be called, and accordingly the same starts closed.
Yes. Otherwise, need not pass any order.
A copy of the last order, a copy of the communication dated so and so 4/8/2025 negi. It is 4/8/2025, Mr.
আজির হেরিটো।
It's 4/8/2025. 4/8/2025, punished by Mr. B. Goswami, learned additional Advocate General, Assam, is placed on record and marked as X for the purpose of identification. Done.
Deeply obliged.
Mr. Mondal is not, Mr. Mondal is here. What do you say, similar order? Or you want to have some instruction?
Yes.
Insufficient document. We'll dispose it of, disposed of.
Obliged. Yesterday, the revenue department.
We ignored that affidavit. What is your case? We ignored that affidavit. Materials here, how do you get over this?
Hearing the loss.
Hmm?
Hearing the loss.
If the urgency was there, who asked you to file the affidavit in the last moment? We were ready otherwise with the matter to hear the matter. Narrow compass. Mr. J. Abbas, learned counsel for the petitioner, submits that the respondent authorities, respondents in the matter have filed an addition affidavit. The respondent number 1 has filed an addition. An affidavit in opposition against the additional affidavit filed by the petitioners, on 3/9/2025. Accordingly, he submits that he be granted further 2 weeks' time to complete his instructions thereon. Also, prayer accepted. A registry to list these matters again on 14/10/2025 for admission, for admission. 14/10. Before vacation. Okay, done. When? 16? No. To last week we are not putting. This will require some hearing. 16? 18 will be too near. 16. 16/9/2025. 16/9 ko dia. 2 weeks ho jabo na. 1 week ko dia. 1 week lage ko dia. Complete his instruction. Granted 1 week. Done. Huh? Interim order passed earlier to continue till the next date of listing. Baki kek. Dia banai din. Done with 2 o'clock. Baki kini kek koi. Mr. Gogoi, everything done with? Nicely. When did you come back? Yes.
My lord, I have gone through the provision of the, my lord, the act also, my lord. As per section 38, my lord, only after payment of the compensation only, my lord, land can be acquired. Here in this case, in the affidavit, they have stated, my lord, if your lordship see the page 52 of their affidavit, second affidavit, my lord, they have stated in paragraph Roman 3, my lord, that while perusal of LA case record, it is stated, it is seen that notice number so and so, a single notice in the name of the both particular was issued with a request to furnish required document for claiming compensation amount. On the other hand, it is observed that the notice was received by one Alauddin grandson, Oniman, on behalf of Khudeja Khatun, who is one of the petitioners.
Mr. Kulta, here the money has been sanctioned.
Yes.
Right? Money has been sanctioned. Now it is the question of apportionment.
Apportionment.
Who will get what?
Yes.
Right? So now the issue here is that they admit that you are entitled to a share. It's not that it's not admitted. The only problem is that the other co-patadar is not before the court, before the authorities. And we don't know where he is. Now the apportionment cannot be made. Act 2013. Yes. Now, if you can come to the 2013 Act,
Yes, my lord. So Lordship
76.
26.
Now, it will be covered by this, and this has to be decided by an authority, and that authority you will find in section 51. And it is the court of the principal civil court, that is the district judge. District and session. There was a notification also. So you will have to, the Kala can always refer the matter to, you can appear before the, make an application before the Kala, additional deputy commission, district commissioner. He will refer the matter and the matter will be settled there. As to the, if they are not there, the court will find out a way out to civil court. It can take evidences and all, find out a way and then decide this. Otherwise, what will happen is that 50% it is being released, we direct. So God knows where you will be tomorrow. If the money is to be recovered, these are basically people from the villages, born, this, that will be a cumbersome exercise.
Yes.
Tomorrow somebody comes and says, no, this land is 80% mine, 30% is, and a partition case is filed, it is divided 80-30. Now, how do the authorities recover that 20%? You get my point?
Yes, Lordship.
That's the only thing. So you appear before the Kala, make an application before the Kala. We will direct that the Kala would refer the matter to the authority under section 76.
For a moment, Lordship. Section 23, if your Lordship see, my lord. 23, my lord. Inquiry and land acquisition award by collector.
No, here these things have been done. The money is ready,
Yes.
but it's not been able to disburse because the appropriate apportionment cannot be made.
Yes, that is why, my lord, Lordship, subsection C, my lord. 3C, the apportionment of the said compensation among all the persons known or believed to be interested in the land, or whom or whose claim he has information, whether or not they have respective.
Fine. Once this cannot be done, that is why the provision of section 64 and 76 is there. (64 and 61 is
4 is there, my lord. Forensic.
64. This is when you have not accepted the award. You are not accepted. Here you are accepting the award, but the apportionment cannot be made because of the dispute. That is 76. Right, Mr. Bachaji? Huh? Here you are ready to accept the award. Award you are not disputing.
Yes, yes.
It is only the compensation, how it is to be done. That is apportionment.
Yes.
So, Mr. Kolta, what do you say? If you
Yes,
want
yes,
to
yes,
have
sir.
further,
No, my lordship can refer. Disposite of.
Mr.
direction.
N.K. Kalita, learned counsel for the petition, also heard Mr. A. Bachaji, learned standing counsel, Revenue Department, respondent number 1, and respondent number 1 and 2, Mr. D. Gugoi, learned standing counsel, Forest Department for respondent number 3, and Mr. B.J. Soikya, B.J. Talukdar, learned senior counsel, assisted by Mr. P.K. Medhi, learned counsel, appearing for the respondents number 4, 5, and 6. Also, the petitioner in the present petition has raised a grievance with regard to non-release of the assessed compensation amount for the land, for acquisition of the land belonging to the petitioner. Also, the petitioner has further prayed that he, being a co-pattadar of the said land, the respondent authorities are required to release a proportionate share of the amount of the compensation amount to the petitioner in the matter. Also, subpara. Para. As projected in the petition, The father of the petitioner, namely Sheikh Shahid Hussain and one Sheikh Hamid Ali, were the joint pattadas and possessors of a plot of land measuring 4 bigha, 4 kata and 14 lesa, covered by Dag number 49 of Patta number 5, village Aldibari under Mausa, Kazirunga, Golaghat district. Also, the father of the petitioners
petitioners.
of the petitioners, father of the petitioners, passed on, on 10/9/1985, leaving behind the mother of the petitioner, of the petitioners, and the petitioners as his legal next of kin. So it is also projected that the mother had also subsequently passed on. Full stop. The petitioners, being the next legal heirs of late Shahid Hussain, they being in possession of the land, were also paying the assessed land revenue to the revenue authorities. Also, subpara. It is under the above circumstances that the respondent authorities had proceeded to acquire the land possessed by the petitioners for the purpose of the 5th addition to Kariziranga National Park. Also, accordingly, a notice came to be issued to the notice dated 8/3/2023 came to be issued in the name of the deceased father of the petitioner with regard to the acquisition of the land under the possession of the petitioners and assessment of compensation thereof. So the assessed compensation, the compensation as for acquisition of the land was so assessed as rupees 19,30,125 Wadzodolihidivo. Also, the petitioners on receipt of the said notice approached the respondent number 5 with all requisite documents and had prayed for release to them of their due share of the compensation amount assessed for the land, assessed for the land so acquired from them. It is to be noted that the acquisition was made in respect of 3 bigha, 0 katha, 1 lesser, right?
So, acquisition, 2 bigha, 4 katha.
Was made, no.
2
That
bigha.
is your share, 2 bigha, 4 katha.
And the total
Entire 2 bigha, 4 katha,
14 lessers.
14 lessers. Out of the land possessed by the petitioner along with the co-pattada. Also, the respondent authorities, Sapara, having not released the compensation as assessed in the matter to the petitioners, even such release being not made with regard to the extent of the share of the petitioners in the land in question, the petitioners have instituted the present proceeding with the prayers as noticed herein above. Mr. N.K. Kolita, learned counsel for the petitioners, after reiterating the facts noticed herein above, has submitted that the respondent authorities, even after assessing the due compensation receivable by the petitioners, have not released the same inasmuch as the co-pattadar of the plot of land in question had not appeared before the respondent authorities for completion of the requisite formalities. Mr. Kolita submits that the amount as assessed by the respondent authorities for the part of land, for the land as acquired from the petitioners and the co-pattadar has not been disputed by the petitioners. However, they are aggrieved by the non-release of the compensation amount to the extent of their share in the land so acquired by the respondent authorities. Accordingly, he submits that the respondent authorities be directed to release at least 50% of the assessed amount to the petitioners herein, which would be commensurating to the share the petitioners would have on the land that was so acquired by the respondent authorities. Per contra, Mr. B.J. Talukdar, learned senior counsel, has submitted that the respondent authorities on completion of the process of acquisition and having prepared the award, it would come to the notice that with regard to the land claimed by the petitioners, by the petitioners to be acquired from them, there were names of two pattadas, that is Sheikh Hamid Ali and Sheikh Shahid Ali Hussain. And the total quantum of land was denoted as 2 bigha, 4 katha, 14 lessa. Also, Mr. Talukdar has further submitted that the other co-pattadar, Sheikh Hamid Ali, had not appeared before the respondent authorities for completion of the formalities. Accordingly, it is submitted that if the authorities release the 50% compensation amount in favor of the petitioners, and there is a subsequent claim made by the co-pattadar Sheikh Hamid Ali and or his legal heirs for a larger share in the compensation amount so assessed, the respondent authorities would not be in a position to meet such demand after making payments to the petitioner herein, and accordingly, a dispute having arisen with regard to the apportionment of the amount among the claimants, the said amount was not released by the respondent authorities. Anything more? Nothing? This much only? Accordingly, he submits that the present petition would not mandate an acceptance and the respondents are to appear before the competent authority land acquisition, that is the additional deputy commissioner, Gulaghat, for further.
Now it is code district Bokaghat.
Additional deputy commissioner, co-district Bokaghat, for having the matter referred to the authority as envisaged under the provisions of section 51 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013. Also, I've heard the learned counsel for the parties and also perused the material available on record. The facts noticed herein above has not been disputed by the parties to the proceeding. Also, the acquisition of land wherein the predecessor in interest of the petitioner was a co-pattadar has also not been disputed by the parties to the proceedings. Accordingly, it is an admitted position that 2 bigha, 4 katha, 14 lessas of land out of the total land covered by DAG number 49 of Patta number 5, village Haldibari, revenue circle Bokaghat in the co-district of Bokaghat was acquired by the respondent authorities for the purpose of the extension, for the purpose of the 5th addition to Kaziranga National Park. Also, the materials brought on record would reveal that the Father of the petitioner, late Sheikh Sahid Hussain, was a co-patadar of the said plot of land, along with Sheikh Hamid Ali. The petitioners have not disputed the award so made in their case, and they also have also not disputed the amount of compensation which was assessed as rupees 19,30,125. Also, subpara. However, the amount in question was not released to either the petitioners and the co-patadar, Sheikh Shahid Hussain, no, Sheikh Hamid Ali. It's ulta. It's your father is?
It's a Sheikh Sahid Hussain.
Sheikh Sahid Hussain. Upor ulta kore diba de. Released to Sheikh Hamid Ali and his legal heirs, inasmuch as neither Sheikh Hamid Ali nor his legal heirs had appeared before the respondent authorities for completion of the requisite formalities. It is further contended by the learned counsel for the petitioner that the whereabouts of Sheikh Hamid Ali and his legal heirs are not known to any person in the locality. Also, accordingly, in view of the above discussion, it is seen that the dispute in the present proceeding pertains to the apportionment of the compensation amount as assessed in the matter by the competent authority. Also, while the right of the petitioners to receive the said compensation amount is not disputed, what is in dispute is to the share that they would be entitled to be what is in dispute is the share that they would be entitled in the said compensation amount so assessed by the respondent authorities. Subpara. Envisaging a position as arising in the present proceedings, Section 76 of the said Act of 2013 had mandated that when the amount of compensation has been settled, if any dispute arises as to the apportionment of the same or any part thereof, or as to the person to whom the same or any part thereof is payable, the collector may refer such dispute to the authority. The term authority, apostrophe, single, as finding mention in Section 76 of the said Act of 23 is described under the provisions of Section 51 of the Act of 2023. Also, the authority is the Land Acquisition, Rehabilitation and the Resettlement Authority, and such authority has to be specified by the appropriate government. Also, in terms of the provisions of Section 51, bracketed 1 of the Act of 2025, as well as the provisions of Rule 45, bracketed 1 of the Assam Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Rules, 2015, the government, the competent authority, wide notification dated 27/6/2024, declared that the courts of district and session judge of all districts of the state of Assam shall act as land acquisition, rehabilitation and resettlement authority within their respective jurisdiction to exercise powers and authority conferred on it by or under the Act of 2013 until further orders. Accordingly, for the purpose of the provisions of Section 51, it is the court of the learned district and session judge in the state of Assam that has been now designated as the Land Acquisition, Rehabilitation and Resettlement Authority. Also, as noticed here in above, the dispute in the present proceedings being to the apportionment of the compensation amount already assessed, this court is of the considered view that the petitioner herein has to take recourse to the provisions as set out in the Act of 2013 for such an eventuality. Accordingly, the petitioner is directed to approach the competent authority and under land acquisition, bracketed Kala, CALA, Bukahat, referring or the dispute, referring the issue with regard to apportionment of the awarded amount to the authority as envisaged under Section 51 of the Act of 2013, read with the said notification dated 27/6/2024. Also, the Kala on receipt of such application from the petitioner shall refer the same to the authority as set out in the provisions of Section 51 of the Act of 2013, read with the notification dated 27/6/2024 within a period of 15 days from this date of receipt of such application from the petitioner. The authority, upon being referred with the dispute in question, shall proceed to adjudicate upon the same and render its decision in the matter expeditiously. Also, the manner in which the amount assessed with regard to the acquisition of the land wherein the petitioners are co-pattadas would now be done in terms of the decision that would be rendered in the matter by the authority to Damodama authority. Full stop. With the above observations and directions, the present petition stands disposed of. Ito tumi rahida wasn't done anything? Nothing? Say it's okay.